Welcome, everybody, to the English show. I'm attorney Gil Brito from Beltran Brito, and I have with me the distinguished, the incredible attorney Andrea Parra, or as some people call you, Andrea.
Only some people. Hello, everybody. Andrea Parra here.
We don't have Stephanie today. Stephanie had a mask on a little while ago, not feeling too well, but she is working because that's her. I told her to go home. And we are focusing, a little bit different than the Spanish show. Andrea, what we're doing here is really, number one, it's in English. I'm not sure if you noticed.
I think I caught on to
Not
that
the
one.
easiest thing for us sometimes, okay? Because we're very much immigration Spanish. So now we got to flip the switch, immigration English. The cool thing is some people were telling me that this show is being translated in Spanish.
And I believe that.
But via YouTube, I guess like automatically.
I believe
somebody
that.
was telling me that yesterday. I was like, wow, that's cool. So, a little bit different than our Spanish show. We're going to really focus on the fact that we like to have a topic for the show versus the other one that's really more Q&A. It's really talking about news. I'll start us off with a little bit of news. And that's for people to realize that there's going to be a significant change in work authorizations and the period of time that work authorizations are approved for certain categories. Okay. Think asylum, adjustment of status, certain categories. Previously, people were receiving for 5 years. Okay. They're going to go ahead and reduce that down significantly. If I'm correct, adjustment of status is going to be 18 months and maybe asylum was one year.
I believe so.
1 year, between 1 year and 18 months for asylum as well. And they're going to require people to renew those more frequently. The reason given for that is the same reason that they have the new policy on the 19 countries is for security. And they want to continue to vet people, and they want to vet people on a 18-month basis, on a yearly basis, if you have benefits that you've applied for with the with USCIS.
Right, some form of control, let's say.
Yeah,
extra form of control.
It's what they're trying to do, and they're trying to clearly look. The relationship between certain countries is not fantastic. We know that. I think that goes into a lot of what's happening to certain nationalities right now. Unfortunately, it's just the reality. The reality is that, yes, things are incrementally a little bit tougher, not impossible though. But the good news is they're continuing to accept cases, even though they're going to start vetting, Venezuelans more, Cubans more for green card applications, for asylum applications. It doesn't mean you can't file those. You can file those applications. It just means that it's going to take longer. That's what I really do believe what it means. And they're going to do whatever the security checks that they need to do for those green card applications, for those asylum applicants. And again, kind of going with the theme of the administration is constantly one of doing things for security of the United States. Okay. Whether that's necessarily true or not, for every policy that's being implemented, we're not sure. We kind of just ride the waves.
Yeah, we adjust.
And we make
it work.
We adjust and we make it work. So just a little bit of news there. Topic for today. Anybody has questions that they have, they could ask the live question. We'll get to it. Ideally, your question is in English because...
Ideally. If not, we will answer in English.
We will translate it in our minds. Gabriel has a question for us anyway, so I'll hit it off. If I'm laid off with a TN visa, do I get a grace period to leave, find a new sponsor? Does this switching require a new TN visa or just an updated sponsor? Okay. It depends how you do it. So you're going to have a 60-day grace period on most non-immigrant visas, especially if you're laid off. Okay. If you're laid off, technically, even if you quit, you could still potentially do it. But if you're laid off, definitely it's very clear. You have a 60-day grace period. That is to find a new sponsor. You file a change of sponsor petition. You could do so with an I-129 within the US, or you could apply for a brand new TN it depends, if it's like Canadian border, if it's Mexican. If it's Mexico, you're going to go ahead and not do it at the border. You're going to do it at the US consulate. Okay. But you do have that 60-day grace period to make the change. If you do not file a change after 60 days, you're in violation of your non-immigrant visa status, and you should depart the United States and process a new visa application outside of the US. Thank you, Gabriel. We're going to discuss I-751s.
Let's do it.
So we should drop it in?
Let's
drop it. Should we drop it in? Is that too much?
No, do it. Do it. So people can see it.
I'm not.
Try to.
There you go. There you go. There you go. So, Andrea, what's I-751?
All right, we're removing the conditions of the green card. So pretty much what it means is if you applied for a marriage-based petition and you were married for less than 2 years at that time, you'll get your green card, but it'll have conditions. So pretty much you'll get it for 2 years. And when you file the I-751 is to remove those conditions and be able to get this green card without the conditions.
There we go.
Okay?
I think that's a record for how many times you could say the word conditions.
I'm trying to break
in a
records here,
sentence.
Gil. That's what I'm here for.
So you file that within, ideally in the window of time, 90 days prior to your green card expiration. So basically, you were in a valid marriage, everything's great, but you were married less than 2 years at the time they gave you the green card. Fantastic. You now have a green card. You have a 2-year green card. Why didn't they give me a 10-year green card? Because they want to see your pretty face again. They want to see you. They want to hear from you. They want you to file, and they want you to pay some money and file this application to go show that you're still married. Okay. You know, there's a couple of ways of filing that application, Andrea. You know, like the issue is, what happens if we're no longer married?
You could still file that I-751. You just pretty much have to demonstrate that at the time that you guys were married, it was real. Okay, so bona fides. You need to demonstrate any sort of evidence that you could think of that demonstrates, hey, look, you know, whether it be pictures of you guys together, affidavits from people you know, them like pretty much confirming the fact that you guys had been together during that time, and there wasn't a sham. Okay, the purpose of this is the USCIS could see, hey, look, it's not like the person just applied for this green card based on marriage just to get this green card. Okay, so that's why they give us for a shorter amount of time to have that checkup and seeing like, hey, okay, let's see if during this time, these people were still together, okay?
Yes. Good tips there are going to be making sure you continue to file joint tax returns, continue to have a bank account, continue to have a joint domicile, driver's license, insurance together is a good idea. You know, if you file jointly, meaning you're not divorced, that means that you likely will not have another immigration interview. They might send you an RFE requesting additional information, which you could respond to. Just keep in mind, you should make the effort to file as much as possible in that initial filing. They were taking on average up to 33 months, I think we saw, and then they started scaling back closer to 24, then 22. Then I think recently I have seen in our office 1 year,
Correct.
1 year and a half
Correct.
as the average to have an I-751. But what happens if unfortunately you're separated, not yet divorced, but have already filed for divorce? What can you do? You could still request a divorce waiver with the intention. Previously, you cannot do a divorce waiver until the day after you were divorced. Okay. But now what they've done is they understand it's like this is such a lengthy process that potentially people were going to go ahead and be divorced even during the process. So what you can do is, if you could request a divorce waiver if you're already divorced. My preference is that you have a final divorce decree. That is, I think, the best situation. But there's a lot of people, you know, divorces sometimes are messy. They take a long time. You might have kids, whatever the situation is. So the reality is that maybe we're not going to make that 90-day window that we need to already have the divorce. You could file for divorce soon thereafter, file the I-751 within the window of time you're supposed to. And whenever the divorce is finalized, you can send a divorce to USCIS. You can notify them. They have a vehicle there, a mechanism to make sure that that document gets to them and it gets to the file. We've done it. You might also get an RFE about it, and then you submit the divorce at the RFE stage. Just keep in mind, with divorce waiver cases, you almost 99% of the time probably are going to have a second interview. And that interview is just going to be you, the I-751 applicant, the green card holder, and the immigration officer. Your ex-spouse
stays out of it.
Okay. What else? Time frame we've discussed. Really important, this point, where the moment, so this is a common question. The moment you file for an I-751, USCIS will automatically extend your green card for 48 months. That means that with your expired green card and with the receipt of the I-751, you're legally able to travel, continue working, you are a lawful permanent resident in all regards, you have an expired green card, and you have the sheet of paper that says you have an extra 48 months. That used to be less time, I would say. I think it used to be max like 24 months, and then they even extended it for 36, and then they finally pushed it to 48 because I think those cases were taking such a long time.
They have their reasons.
It wouldn't surprise me to see that scaled back, just like they scaled back the work authorizations. They could scale that back to 24 months again.
Yeah.
Again, in an effort to continue to vet people. We kind of went over all the types of evidence, that you should take on that. I think it's just discussing kind of tips for that. Don't stay in a shitty marriage
just for this.
If you need to get a divorce, you get a divorce. If you were really married, you're fine.
Correct.
Don't worry about it. Okay, as long as you had a bona fide marriage, as long as you have good evidence that you're really married, you have good affidavits, you could show. Listen, I have clients that are in this stage that are in abusive relationships
because they refuse to get divorced, thinking that if they do, this is the end of it. Like, that's it.
Yeah.
They will no longer have their green card.
Yeah.
And that's not the case.
And you should not be a victim waiting to have the conditions removed of your green card. And it's the advice I give all my clients, the same advice I give you guys. Do not be in an abusive relationship just to maintain some sort of legal status in the U.S. There's other ways around it. You could talk to professionals. We could go over a potential plan for you. And there's always options, especially if you currently have a green card. Okay. If you don't have a green card yet, and you're in this process, and then there's options like VAWA and stuff like that, available, Violence Against Women's Act, but not just for women. We've represented abused spouses, men as well. Just keep that in mind. So I just feel that I kind of had to say that.
It's important because some people don't know that, and some people might stick around just thinking that, all that hard work is going to be, go down the drain for no reason, when that's not the case. There are options. You have options.
Yeah. Especially, what we see a lot of, that people use immigration status
like to extort the other person.
To do. And I'm not talking about money.
No.
We're talking about emotional extortion.
Yeah.
And to extort and torment another person. And I said, no, you don't have to subjugate yourself to that.
That's why these options are put in place.
That's it. Let's go. We have a few questions.
There's one here.
Go for it.
All right. So Natalia Quintero, best legal advice for people with a green card and without status if we have any encounter with ICE officer, what to do, what not to do. With green card and without status.
Well, you have status.
Yeah, you have status. That's a good thing. Green card, you're a green card holder, so you're a lawful permanent resident. I would say especially now, as an extra protection for most people, because that's their worry, okay? Maybe keep your green card with you to show, like, hey, look, I'm a green card holder. Here it is. You could see it. If you have a driver's license, that also shows that you have status. If you have a social security, you could also show that you have status. It's different documents that you could keep with you that show the officer in every way possible, hey, I'm here lawfully, in order to try to avoid any misunderstanding that then would cause for you to be detained or whatever the case may be, or go through like this unsavory process when that shouldn't be the case, because with a green card, you should have status.
Fine. Yeah, what I think Natalia was saying also is like, talk to us about if we have a green card and if we don't have a green card, like for people that don't. Okay. So people that don't, unfortunately, Natalia, you're in a bad situation.
Right.
And if you do not have legal status currently and you are stopped by the police, yes, they could, it could be a problem. They can call ICE. It's obviously there's like the civil penalty of it, which is you traffic ticket for not having a driver's license, all this type of thing. But that's like neither here nor there. The most important thing is yes. Do you have an order of removal? They could pick you up.
Yes.
Like they could put you in removal proceedings. They could take you to Alligator Alcatraz.
Or wherever.
Or
at this
wherever at this point. Supposedly they're going to be opening up a whole bunch of those places all over the place. So I'm just of the opinion that what to do, what not to do. Definitely don't lie. definitely don't try to run away. I don't know if we've seen some of these videos, but
Correct.
I've seen some aggressive videos. Like, that's a real bad idea.
Also,
Like,
try, keep a low profile. Okay. So if you don't have any lawful status whatsoever, that means you also don't have a driver's license. So if that's the case, don't drive. Okay.
Yeah.
Try to avoid things like that put you in a situation where you might be at risk of getting pulled over, and then you have to go and explain this. And at the moment, that's the type of thing you want to avoid. You want to maintain low profile and try to fix your immigration status, if possible, as soon as possible. Okay.
It's so tough.
It is.
It's tough right now. Things are tough. The advice is tough. It's hard. It's hard for people to not drive. It's hard for people to, not try to earn some sort of living. It's just hard. If you have kids, you go to school, you got to feed them. You got to it's a tough time, guys, that we're living right now. Alejandro, EB-1 approved, consular processing, Argentina. DS-260 has already been completed, but civil documents section to upload the document still doesn't appear. Is this normal? Shows your case is currently at NVC. Okay, that part's normal. But they should have, so this is important. You do not upload documents for an EB-1 case via the online system. Read the instructions. If you look at the instructions there, you need to submit the civil documents via mail. Okay, not the originals. Copies. The originals, you keep them for your interview, okay? But the actual copies, for example, birth certificate, marriage certificate, letter that you don't have a criminal record, back in Argentina, this type of evidence that they request on the document sheet, you need to physically send that in. After you physically sent in your passport, all these things that they ask for, the copies, they're going to go ahead and send you an email 60 days later saying your case is documentarily qualified. So family-based cases, you upload on the online system. Employment-based cases like an EB-1, EB-2, EB-3, you have to physically mail in the documents. Why that's like that, I have no idea. Like I always say, welcome to America. I don't know what to tell you.
Make it complicated for no reason.
They made it very complicated for no reason. I'm going to hit Diego.
All right.
I have a J2. If I submit an EB-2 NIW and is approved before my wife renews her J1, can that jeopardize her process? So if they ask her, Diego, during her J1 process, if she has the intent to immigrate to the U.S., let's just say she's applying for the visa at a U.S. consulate, there's a question on the DS-160 that says, have you ever been the beneficiary of an immigrant petition? In my opinion, if my husband has applied for an EB-2 NIW, the answer is yes. I am the beneficiary. I'm the beneficiary of my husband's petition, and she needs to put that information. Can that be a reason to deny her J1? Yes, it can be, especially if it's at the consulate. Okay, just keep that in mind. If she has a J1, she's just extending the 2019 and the program and all that. And she's still in the U.S. and not traveling. I think that's probably okay. The issue is going to be when you apply for it at the consulate. Also, keep in mind if she is subject to the J1 waiver, home residency requirement, meaning is she required to file a waiver? If she's not required to file a waiver, fantastic. You could proceed where you could file an EB-2 NIW even though you're subject to a 2-year home residency requirement and you have not filed the waiver and you do not have a waiver approved. However, you will not be able to file an adjustment of status application if in the U.S. or an immigrant visa process through the U.S. consulate if you have not acquired the J1 waiver previously to initiating those processes. So what I've done in the past is the EB-1 has been approved. When the waiver has been approved, then we start the consular process for the client or the adjustment of status, not beforehand.
Also, I have a lot of clients that ask me this question. Wouldn't it be that just filing the EB-2 NIW, that's not necessarily immigrant intent because you haven't filed the adjustment of status? Couldn't that argument be made?
Yeah.
It might work. Just saying.
She can't. Yeah. I mean, we've made that argument. I'm just like, with the climate I'm in.
I know.
I'm playing it by the book. I'm trying to do everything squeaky clean. So as conservative as possible. But that's the reality.
I agree.
Let's talk for you handle. I'm sorry.
Oh, we did that one already. Yeah.
All right, cool. Natalia, this great. So let's talk a little bit about what's happening with Venezuelan clients, okay?
Yeah.
And Cuban clients. So you have this new policy memorandum from Homeland Security comes out 10 days ago.
Yeah.
Something like that. Let's talk about that.
So main thing to keep in mind, this new memorandum that came out is pretty much like an extension of what was already previously said when we got the presidential proclamation, that it pretty much had certain countries, okay, that certain things were going to change, okay? So this new policy memorandum, what it's saying is you can still apply, for example, for a green card, okay? Like you could still apply for, you could file your adjustment of status. You could file these petitions. But what we were saying at the beginning is things may have a delay, okay? So aside from these processes having these delays, for example, for Venezuelans that are applying for these, that they're applying for the I-485, what we used to see is employment-based petitions didn't always get an interview, okay? Now, for these countries, okay, that they're deemed not...
security risks.
Yeah, security risks, okay? That being the case, what will usually happen now, what we're expecting for it to happen, is that you will have an interview, okay? You will have an interview where you're going to have to pretty much take all the evidence that was submitted in the I-485 with you and demonstrate that you're a good person, pretty much, okay? So what we're seeing is it doesn't mean that these countries will no longer be able to file this type of petition while here in the US, okay, as an adjustment of status, but that there will be other steps that need to be made or that the process will be delayed in comparison to how it was before because of these security checks, okay?
Yeah. Delays is probably the issue for most people.
Correct.
I would say most people probably are not security risks.
I agree.
Like I would say our clients.
Most people.
Yeah. Just our clients, I would say, are just not security risks. So what, the whole kind of good character aspect of it is concerning to me.
Yeah.
We've seen it recently in a few non-immigrant visa filings that USCIS has sent a request for evidence. And the request for evidence lays out that there's a presidential proclamation that they understand currently only applies to, let's just say, Venezuelan nationals outside the US. However, we've made the decision that we're going to apply this in the US, even though the presidential proclamation clearly delineated, said this is for people outside the US, not inside the US.
For the record, it explicitly says this, okay? Like this is a thing.
Yes, it says it explicitly. So they say, to overcome this proclamation, you need to provide evidence of your good character. Do you, go to church? Do you donate, your time to organizations?
Community service.
Do you do community service?
Can your friends attest to these types of activities that you do to benefit the United States and show what a good person you are?
Yeah.
It's a tough one.
It's problematic.
Yeah.
It's real problematic.
Because realistically speaking, usually people do that sometimes. They don't do this all the time. Like you may do some charity work, you may donate some things, or, there may be an event to clean up a beach type of thing.
Yeah.
But it's not something that you regularly do.
Yeah. I'm concerned about it. I'm concerned about it if they start applying that to every non-immigrant visa here in the US, to again, we've seen it handful of times in very particular situations. So hopefully it's not spread across the board. But if we start seeing that, so this is what would happen. They were approving all the change of statuses for people that had TPS and traveled correctly and did everything. And then we went ahead and filed those change of status and adjustment of status, and the green cards were being approved and the change of status were being approved. Every once in a while you see a green card be denied or a visa denied, but it wasn't anything, it was like 10% of the time. 90% of the time is being approved.
Right.
And then I would say recently now they're hitting us saying again and again that TPS is not a legal status to file a change of status or an adjustment of status, which is completely contradictory to current law. We're talking case law as well as statutory law. Okay. So we make the legal arguments, we provide all the information, and we have many of those cases currently pending decisions. We have some that have been denied. We're waiting for motions to reopen to be decided. The issue really starts becoming that all those people that quote unquote stopped having legal status in the US, okay, you basically have a 180-day clock. That 180-day clock, I don't want to even be close to those 180 days, but you have a 180-day clock to really depart the US from your non-immigrant visa status being expired. What is that date? For a TPS holder, it was November 7th, 2025. 180 days in the future. If you leave in that window, you're not subject to something called the 3-year bar. You're still able to apply for a visa, a green card, depends the category, outside of the US. Okay. Unfortunately, it's considering that there is a lag on decisions, we've had to now kind of almost, hey, we got to kind of push clients to do things like premium processing, stuff like that in certain applications, just because of the fact that, hey, good or bad, we need a decision very quickly, because if you're outside of that 180 days and you leave, you're not coming back for a long time. Okay. So so somebody says, like, who defends lawful immigrants now? Do judges still stop unfair decisions, or are we unprotected? I say lawful immigrants, we're still okay.
Correct.
Like, I'm still okay.
Yes.
I'm still okay. I'm fighting. Okay. I'm holding on sometimes. If I'm on a work visa, a student visa, I think really the problem becomes people that, maybe you have a criminal record or something like that. I think this is a group of people that visas are being denied, and they're getting this group of people outside of the US. They're getting rid of you. Like, this is the reality. That's a small percentage. That's not that's not most people. If you're a lawful non-immigrant, or lawful immigrant, I'm still convinced you're okay.
Yeah.
All right.
You're protected.
I know it's uncomfortable. It's very uncomfortable.
It's the uncertainty that people are living. It's the uncertainty of not knowing what's going to happen next. Like, who are they going to attack next? Like, what should I be worrying about in the future? And we get it. And fortunately, the people that have lawful status, you do have the law on your side. Okay. You do have policy on your side. You have law on your side, which is pretty much in these cases where we're seeing these sightings of the proclamation, we still have a way to prove the good moral character. Or, for example, when we've gotten that TPS, you cannot change status, or you can adjust status when you've been admitted as under TPS. We have public policy on our side. We have current law on our side. So I feel like that's, we have something to hang on to.
Yeah,
for now.
I think
the
also,
problem. Go ahead.
I was gonna say, I also think that to her point, I mean, it's like, hey, are judges going to do something here? I think lawsuits. I think lawsuits are helpful in this situation. We've been advising certain clients to sue. Some definitely want to do it. Some, obviously are afraid to do so. It's not even a very costly thing to do, by the way. It's not very much money to do that. And if you win, it's fantastic. Potentially.
Hopefully.
Potentially. So yes, I think, like, hey, we're still trying to fight it out. Immigration is not lost. Like, lawful immigration is still there. Like, we're still, look, I'm actively getting O1s approved,
EB-1s,
EB-1s, EB-2 NIWs, F1s. I mean, believe it or not, H-1Bs. I think they're picking in a couple of countries right now. And that is true. They are picking on a few countries right now. And those countries before, Stephanie would say it all the time, that she thinks it's only against certain countries. And it wasn't my experience until it was.
Correct.
And we see it. And I do agree with her now. And I say, yeah, you know what? You were right. It is against certain countries, because I could take two nationalities and I could tell you that you're going to have an easier time with a nationality A than nationality B, obtaining exactly the exact same benefit, everything being equal. That wasn't like that, I would say, even 6 months ago.
I
with
would
my
even
cases.
say there have been clients that we've had that they have a spectacular case, okay? Spectacular, where USCIS even determines that these people meet, let's say it's an EB-1, they meet 8 out of the categories that are required, And then at the end, they would just say, oh, no, but the case is denied on final merits. And we saw a little bit of a disparity with that when it came down to, for example, Venezuelans.
Yes.
Where we saw that we had these clients with spectacular cases, but then USCIS would latch on to what's called final merits, where they would say, hey, look, yeah, you qualify, but not really.
Yeah.
That's the explanation we would get. And that's when we started seeing, hey, they are kind of picking on these nationalities.
And then, we had one recently that we appealed. The gentleman had 5 categories approved, where he's in lawful status with another category, which is fine. So we're like, you know what? He decided to appeal. We went ahead and appealed. And in the appeal response we received in about 5 months.
It was pretty quick.
It was quick. I would say it was quick. In about 5 months, the appeal response was, you know what? He doesn't qualify for those 5 categories because of A, B, C, D, and E.
So
and
pretty much they gave him 6.
Oh,
they
6,
gave him
sorry.
6 categories.
Right, 6.
And they took all 6 away.
Right, and they took
which
them away.
was ridiculous. Like we had never seen that.
No, I've never seen that.
Like, does it make sense?
You could take out a couple, right? Like that's reasonable. Like you're gonna be like, you know, we think the officer erred in giving you these categories, whatever. Maybe if you want to pull it back under 3, because that's the EB-1 criteria. You need to fulfill these 3 of the 10 criteria. Okay, I understand. I've seen a few of those things before, but to take it all away,
all of it, it was ridiculous.
It is kind of nuts.
All away.
What do you even explain? Like, what do you even say to that? You're like they're like, yo, what should I do here? You know? And I'm like, I mean, refile probably, not right now.
No, and
Not
drop
right
that
now.
subject. Okay,
Yeah.
like at that point, I feel like
Yeah.
you're just picking at a losing battle at that point.
Yeah,
okay?
I mean, with the appeal, denial, and all
Correct.
that, 100%. Yeah,
you don't want to waste your time or money with that.
That's it. You know, we got a couple good comments here. You know, Emma, should I contact my members across to challenge ICE injustice? Do congressional inquiries actually help? You know, yes, they do in some things. Like, I think you should always contact congressional assistance when you have the opportunity to do so, Emma. I'm talking about in any regard. Like, they actually do represent you. You know, and it doesn't matter. I'll just give you an example. It doesn't matter if you're legal in the U.S. It doesn't matter if you're illegal in the U.S. It doesn't matter. You know, I've every situation there, like, you know, people that have cases pending, people that are unfortunately being detained by ICE, family members, stuff like that. Can you, you know, kind of acquiesce and go to these options of like congressional assistance? I think it's worth doing it. Just keep in mind which one you're doing, like which one you're contacting. Like, who are you contacting? You know, it's like contact the office that kind of has aligns with your point of view. Okay, because if they don't, I just got to tell you, they're not going to be very helpful.
It's not going to go in your favor.
Yeah, it's not going. You're kind of wasting your time. Truthfully. So I say yes. Do it. Definitely, I agree. You should do it.
I was actually going to pick that one.
Saw you.
If I wait for Maria Sanchez, realtor.
Cool.
If I wait for adjustment of status, AOS, inside the US, does that put me at risk with ICE? So once you file the adjustment of status with USCIS, you will have lawful presence in the US. Okay? Authorized stay.
Yeah.
Here in the US. So pretty much what that means is you're not accruing unlawful presence. You're not accruing illegal status, let's say. So once that AOS is filed, the beauty of it is once you get the receipt of that I-485 being filed, you're able to have that document that shows you have that process pending, okay? So I would say keep that document around. That also helps you when it comes down to renewing your driver's license. With that document, with the receipt notice, you're able to do so. Like, let's say your license expired. With that document, you're able to renew your license, and that also shows that you have lawful status.
I would have that receipt with me at all
times.
Like, literally, if you're outside your house, you have that receipt on you. A couple things to talk about is, you know, I've seen a few, I'm involved in a lot of forums with other immigration attorneys, stuff like that. And I've seen a few situations where, especially on the West Coast, it has not been in the Miami office necessarily, but we've experienced it in the West Coast, where other practitioners are saying that, yes, ICE can go to those interviews. There's been a person I've been following there that it happened twice to them, to their clients. Their individual situations vary dramatically. Like, it could be somebody that has an order of removal. It could be somebody, you know, so, you know, most cases, I have not seen issues at the adjustment of status interview. We do a lot of interview preps for our clients, and we tell them, and I usually bring it up. I'm like, listen, it's always possible that you could be detained at an interview. What do you do in that case? If you are detained, usually they're going to let you go, hopefully. Okay. They might give you a notice to appear before an immigration judge. I've personally been in a situation where they took my client. This was a number of years ago, and it wasn't during the Trump administration. And they took my client and they put an ankle bracelet on her, on a 65-year-old grandma.
Wow.
They let her go, but they put an ankle bracelet on her because by the way, she had an order of removal. Okay. So they put the ankle bracelet on. Okay. So I would say everything's on the table, unfortunately. Like, where my advice would always be in the past, like, no, you have authorized stay. You're fine. Everything's going to be okay. You don't have to worry about it. Like, that Gil is gone.
Yeah.
Like, that version of me of happy, like, well, I'm so happy, but
you're a lot more cautious.
I'm more cautious, and I'm a little bit more negative on the advice I give, and definitely more conservative. So yes, you're correct. But look, this is the reality. You have to go to the adjustment of status interview. Like, there's no option. Like, it's like, what are you gonna do? Not go? And then they're gonna just issue you a notice to appear in front of an immigration court anyways, Right. So it's like, no, I think you have go with an attorney, go prep. If you have this fear, you could take an attorney. People ask me all the time, Gil, do I need an attorney at the interview? Mostly, no, you don't need attorneys. But nowadays, if you have a particular background or something that causes a slight bit of concern in your green card application or your immigration history, I do suggest that you consider going with an attorney.
I agree. I have to say, guys,
the best.
I am taking offense to the world thinking I am AI. Okay, this is now a thing. You're the best, but also you're AI.
Who did that? Who propagated that?
I don't know. Oh, it was one of our previous clients.
Oh,
that he brought it up for the first time, and I was like, guys, I live and breathe. I am here.
Thank you, Amos. Thank you for watching us, man. My favorite immigration lawyers. Thank you. Yeah. Emma, that was brutal for her. And you know what? I was a younger practitioner then, so you're like, what the heck do we do now? Like, what do you? But you know what? We got to resolve at the end of the day. But it is scary what's happening. What's happening right now is not unprecedented. I know people make it sound like it's unprecedented, and like it's like, listen, this has been happening with immigration during the time that I've been an attorney. It was just really easy the 4 years prior to this administration.
It's a shock.
It's a shock. It's because during those 4 years, they weren't doing any of these things. Like, yeah, they were still removing people, but not that much. And they were letting a ton of people into the US via the border. So that, like, a lot of things happened there that were not. So yes, I'm never saying one administration's worse or better or this or that. It's like, yeah, things are a bit tougher. I've already been through Trump 1. I'm going through Trump 2.
And people also need to know.
Do you think there'll be Trump 3?
Honestly, let's keep it as constitutional as possible, guys.
If it's Trump 3, I'm out. I'm out, yo.
To be fair, guys, and this is something that happens a lot now, not everything you see on the news is true, okay?
Yes.
And I feel like that's also where this fear is coming from, where people see, some parts of it might be real, but a lot of it is not, okay? A lot of it is just exaggeration or worst case scenario, or something that happened to one person that they're saying that is just this common thing happening over and over again, when that's not the case. So I would say, if you guys have some sort of fear or some sort of question, contact the correct individuals that will give you the right answer, okay? That will tell you what to actually fear and what not to fear, instead of going down this rabbit hole of everything you see in the news, when in reality, they're just trying to scare everybody with the worst case scenario.
That's it. Let's take a couple questions. TPS, change of status, F1, EB-3, I-140 approved, priority date, November 2023. I don't have the visa bullet. I think it's July. Hold on. Give me a second here. Let's pop it up. Visa. I like to talk exactly. What are we looking at?
Hold on, let me check.
I'm sorry. Priority date, EB-3, July, everything before July 1st, 2023. Okay. So you have a little bit of a wait. TPS, change of status to F1. I'm assuming, Wayne, that the F1 was approved. Okay. Which, by the way, we've seen a ton of those.
Yes.
And we've done them. A lot of TPS, change of status to F1 successfully. EB-2 NIW, how long might this take with this situation? Is it better to go back for consular processing? No, I don't think so. I believe it or not, I think it's better here. You file the adjustment of status in, I don't know, 6 months or so, 7 months, whenever your visa number becomes available. You file for that adjustment of status. Yes, you understand that it will take a while. However, you're able to adjust. Via the consulate, given the presidential proclamation, you cannot receive an immigrant visa outside the U.S., technically, unless you have dual nationality. If you have dual nationality, we can use the secondary nationality, which we are doing successfully, and you're able to receive your immigrant visa abroad. If that's not your situation, if you're not a dual national, stick to the U.S. and do everything over here, if you can.
I have one over here. South locomotion. Hello, lawyers. When responding to an EB-1 RFE, what tends to matter more to USCIS, adding new independent evidence or clarifying and strengthening the contextual narrative of existing evidence? I would say it's a combination of both. Okay, so we want to make sure that we're addressing every point that USCIS is questioning in the RFE, every additional, like let's say that they're asking for clarification about something, you want to make sure you address that. But we also want to make sure we're including new evidence. However, keep in mind that let's say it's for the press category, okay? Keep in mind that any press that was published after the initial petition was filed, they don't have to take that into consideration, okay? So when you're thinking of new independent evidence, try to make sure that if it's for press, that it's evidence maybe that you didn't include, but that already took place before the petition was filed. But we also, what I was saying is, yes, you want to stick to the narrative, but you want to make sure you're including new evidence so that the officer sees that that it did happen, okay? So for example, let's say that they're saying, oh, you were invited as a judge somewhere, and they're telling you, hey, we need evidence that this judging event actually happened. You don't just want to say, hey, but we included evidence that it did. No. You want to make sure you try to get something else, whether it's a letter, whether it's a flyer, whether it's a document that shows that you judged somewhere. Or, the idea is to provide that further like corroboration that it happened, but at the same time, you're also sticking to the narrative. You don't want to go ahead and start filing, like discussing new things that weren't discussed initially, and then you're not addressing what the officer is actually questioning, okay?
Yeah,
I feel like that's important.
I agree. I mean, I do like new evidence, but why wasn't this provided beforehand? So I think RFEs, you're really strengthening the legal arguments you currently already made. One thing we're seeing, let's talk about this briefly. What's the advice for final merits determination? Like what's the advice there? So you qualified for those 5 points and 3 points, maybe the minimum 3, or hopefully 4, 5, 6, 7, or we saw a person, I saw a person in attorney speaking there that his client had 8 categories. 8 categories. I've never had that, but like I've never had 8 categories.
We had 7,
and they denied a case. Yeah, I've never. Oh, okay.
We had 7.
Oh, I've never had that for me. Yeah. So strengthening it, I think, is, in my opinion, really important. New evidence, as long as the evidence existed prior to the date of filing the application. So like Andrea said, getting new dated press doesn't help you because that just looks like you created that for the purposes of responding to the RFE.
Which they will call you out on.
Well, they will call you on. But back to the final merits determination. When you're putting the final merits determination together, this is me brainstorming right now. Should we include for each category something that clearly indicates we received a NOID recently, which we came up with
the best.
I got to tell you, it's the best response we've ever done in this office, and we won that sucker, and we're super happy for our client because she deserves it. She's phenomenal, and I'm so happy for this person. I've known her for years, and she's always qualified, and I knew she qualified, and we got a ridiculous NOID, and we hammered it, final merits determination with great evidence, point by point, indicating why a person was selected to be a judge because they have extraordinary ability, why they were selected to be a member because they have extraordinary ability. They selected them out of this huge group of talented people because they have extraordinary ability. Were they selected to be the lead of this project because they have, and just hammering it. And we did that to every category. So previously, and I would say us included, and what many attorneys are doing is where, or anybody filing an EB-1, you would do a final merits determination as if it's a summary of the application.
Correct.
I am of the opinion that it is a completely separate and different beast. And we need to, you have to almost treat it like an EB-2 NIW.
Correct.
That you're attacking the prongs. Final merits determination is a secondary prong, and we need to attack it individually.
Point by point.
Point by point, ideally with, you could reuse some of the evidence and some things that point out that'd be a great situation. But if you could get independent things pointing towards that, specifically saying that this person has merit and talent and extraordinary ability because of X reason, A, B, C, and detail it and give it, and you put out together a good amount of evidence for that.
I feel like it works.
Hey, it works.
It worked.
It did work. It did work.
Also, to be fair, for final merits, in case you guys haven't seen it or don't know what it is, they'll usually latch on to a specific line that they'll say, "Hey, look, you meet the requirements for the criterion, but you're not at the top of the industry. Your claim doesn't reach to be that elite portion of the industry." Okay. When in reality, they are contradicting themselves, because for every criterion, you are kind of showing, hey, I am extraordinary because I've done X, Y, Z. So what Gil was saying, and I think it's a great idea, it's going point by point and showing, for example, let's say you have an offer for future work.
Yes.
And you could say, hey, look, I got this offer for this role and I'm getting paid X amount of money because I am extraordinary. Like, you're in every point, you're going back to the same thing, saying, I am extraordinary. I do have sustained the claim. The length of my career shows my sustained the claim. The work I've been doing shows my sustained the claim. I am extraordinary because A, B, C, D, E, so on and so forth.
Yeah.
Sort of go about it like if it was an RFE and that they were questioning every single point. You know?
I like it. We got to think outside the box. This is the English show. Have you been thinking in Spanish?
I have. And every time that you guys have seen me struggle with words, it's because I'm so used to doing consultations in Spanish and speaking to clients in Spanish that I kind of, I don't go with the flow. I get stuck with my words, like if I didn't speak the language. I thought you were going to put the crickets.
We don't have, I was going to put what?
The crickets. I thought that's what
whenever
you
you
were.
So we have more fun with the soundboard in the Spanish show.
Yes.
Yeah. Anyways, that is the English show for this week. Please contact us at beltranbrito.com. Fill out the contact us. It helps me out if you could attach the CV. There it is. If you could attach a CV for me, that would be great to kind of see a little bit about your career. If it's an employment-based case, if it's a family-based case, please provide as much information as possible. A lot of times we'll have one of our assistants reach out and just ask a ton of questions for us. You might get a pesky question like, do you have an asylum pending?
It's on purpose, guys.
And you say yes. And then they ask the follow-up. Do you have anything else? And they're like, no. Are you in love with an American citizen? If not, unfortunately, a lot of those asylum cases, we love to talk to you. We just don't like people wasting money or time. But definitely contact us, vet your case if you feel you qualify. I know we talked briefly initially about the I-751s. If you have a potential removal of condition situation, especially if you have a pesky one that has little issues in it, you might want to reach out to us. I've garnered a good amount of experience doing the difficult I-751s over the years. That's the show. See you next week. Oh, I'm sorry. Thursday, the noon show, the Spanish show.